Okay. Welcome to day two of lectures on legal philosophy. Yesterday we discussed two theories of legal philosophy. One is classical naturalism, and the other being classical common law theories. Now we'll be turning towards what sometimes we loosely refer to as modern theories of law, which basically involve positivism, neo-naturalism, and legal interpretivism. Uh, Neo-naturalism, in a sense, develops from classical naturalism, and legal interpretivism, some say, develops sort of from common law theory, classical common law theory. So we'll say, and but the thing is that these theories are also responding to, in a sense, they're responding to positivism and the changes to our understanding of law that was brought about by positivism, and they are, in a sense, they also present a challenge to positivism, or supplement areas where positivism lacks as a legal theory. So first, we talked about Bentham's critique of common law. Yesterday, we talked about how he said that common law is a dog law, and it is a sort of law that you use to train your dogs, and not a sort of law that um, it's not a sort of law that you would expect human beings to follow. Rational human beings who look to law as a source of as a source of guide of their conduct. So Bentham's ideas had a huge impact on many legal theorists and practitioners, judges, jurists of that time. One of the most prominent among them was John Austin, who wrote somewhere around early 19th century, and he took, of course, a lot of learning from his friend and mentor Jeremy Bentham, and there are many elements of Bentham's own ideas that we can find in Austin. So the principle, I mean, Austin wrote a lot of lectures during his lifetime, a lot of essays during his lifetime that sadly did not gain traction until after his death, when his widow published the collection of his lectures titled "The Province of Jurisprudence Determined." So it was after that his ideas gained traction, to the point that even some of the most renowned judges of the time said that Austin's idea are going to have as much impact on the world as Adam Smith or Ricardo's ideas had on ideas of profit and rent and property. So in a sense, this was an attempt to describe the importance of Austin when we look at the realm of jurisprudence, paradigm shift that John Austin's theory brought to our understanding, the way that we look at law. So, as the title suggests, province of jurisprudence determined, we can understand that it somewhere seeks to confine jurisprudence in its pure domain, so to speak. And that is the domain, of course, of positive law. And it tries to distinguish law from other uses of the word where we might use law, but it is not in its actual sense law. Uh, so, and by his own description, what he's trying to do in this work is he's not trying to tell us what law ought to be or how we should frame laws. Rather, he's describing what law is. So, what he's describing is what law is, and what law not what and not what law ought to be. So there is this is a distinction that he refers to as the distinction between science of jurisprudence and science of legislation. Now, science of legislation, which Bentham talks about a lot, is it's about it is supposed to be, at least in Bentham's configuration, a way that we design laws in a utilitarian manner that sort of best lead to that lead to best outcomes, maximum happiness for maximum number of people. In a sense, we can understand the way that we look at normative jurisprudence today. Science of legislation, in the sense, maybe corresponding to that, but it's not exactly the same. The science of legislation, when we talk about science of legislation, we necessarily separate it from the science of jurisprudence, which is that once a law has come in, like, how do we recognize how law comes into existence, and how do we analyze laws, and so on and so forth. So um, so 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 science of legislation is about creating the laws, and once the laws are in order, science of jurisprudence is about understanding the laws and implementing these laws and so on and so forth. So let's look at what Austin's theory is. One of the beauty of Austin's theory, maybe its simplicity, is the fact that his theory of law can be stated in one line. I mean, that is, of course, that is also a part of its attractiveness, in the sense that just because it is so simply, it can be so simply explained. That is why it is very popular, because it's like, it can be a good idea to guide our conduct if it's simple to explain rather than many complex and many layered, right? So what Austin's theory says, that is, and I quote, law is a general command backed by a threat of sanction issued by a sovereign. So, a general command that is backed by a threat of sanction and issued by a sovereign. Let's unpack this. So, he calls laws a general command. So, it's general as opposed to specific. Uh, Fuller also talks about it. We'll talk about it when we reach to Fuller. That Fuller tries to separate law from managerial directions, in the sense that a manager can just go ahead and ask you to act in one way today and a different way today, and you would not have a ground to complain, right? But laws are general commands, as in, like, and a manager can also say, can two equal workers, they can he can assign different roles to them and jobs to them. They would not have a ground to complain. But law, as we understand them to be general commands, are supposed to treat everyone, the similar people similarly, in that sense, right? And there should be a rational ground to sort of distinguish between the behavior that we meet out to one people or behavior we meet out to other people. It should be general, in the sense that they should not change very frequently. They should stay the same way, so to speak. I mean, there should be some generality to laws, as opposed to managerial directions or executive directions. So law is a general command. Now, what is a command? Command, Austin defines as a signification of desire from a political superior to a political inferior. That there should be, you cannot come, you cannot command an equal, so to speak, right? You can signify a desire to equals. You can go to an equal and say, I would like this to be done, will you do this for me, right? But it is only when there is a relationship of political superiority and inferiority that you can issue a command, that the other person has to follow, in that sense. So command, is, of course, is a signification of desire from a political superior to political inferior, backed by a threat of sanction. So sanction, as per Austin, can either be a punishment or withholding of a reward. And we'll come to this idea of sanction, and the problems that Hart has with the idea of sanction, when we talk about the critique of a critique of Austin's ideas. So it's backed by threat of sanction and issued by a sovereign. Now, how does Hart talk about the sovereign? Hart says that a sovereign is one that is habitually obeyed, and is habitually obeyed by one that is habitually obeyed and does not habitually obey anyone else. So, for example, the government of India, we can say that it is sovereign because it is habitually obeyed by the people, and it does not pay habitual obedience to anyone else. But, for example, we cannot say that it is sovereign, in the sense that, of course, people pay habitual obedience to the viceroy, but the viceroy in turn also pays habitual obedience to the Queen of England, right? So in that sense, Queen of England is the sovereign and not the viceroy in India. So this is idea of sovereignty as put by Austin. So law is a general command, which is backed by threat issued by a sovereign. This is what his entirety of theory of law is all about. Simplicity gives a non-legal terms, for for origination of law, in that it does not confine law to law alone, as we'll see is the case with Kelsen. It gives habitual obedience as a ground for law, and it gives a contained picture of law that is not vague. As in, natural law theories are extremely vague, right? They said that human law should be derived from natural law. There's a lot of open texture there. I mean, you can make anything out of it. But the good thing about Austin's theory is that it is very well contained, in the sense that we can determine the validity of law very easily through it. That what is law, what is not law, we can define very easily through it. Now, what are some of the implications of Austin's idea of law? So, given this definition, what Austin does next is that he separates his ideas from ideas of law from things that approximate law but are not exactly it. Now, what does that mean? uh, he he creates distinction between something that he calls law properly so called and something that is law not properly so called. So what is the difference? Law properly so called for Austin is positive law, a law that it conforms to this definition of law that he has given, right? So what is law? It is a general command backed by the threat of sanction issued by sovereign. If it is this, then it is law properly so called. Otherwise, it is law not properly so called. Now, what is law not properly so called? He talks about two types of law properly not properly so called. One is law by analogy, and second is law by metaphor. Now, law by analogy refers to things like positive morality, something that you should do, should not do. People talk about them as if they were laws, but they're not laws because they're not issued by a sovereign, and they're not general commands backed by threat. Same laws of honor, that's something that this is something that you should do. This is honorable. This is dishonorable. They are laws by analogy. International law, very famously, Austin calls it a law by analogy rather than a law properly so called. Now, what does that mean? International law, as you know, there is no international sovereign that issues these laws. These laws arise as a matter of custom. These law arise as a matter of no relationship of political superiority or inferiority in that case. So this is not properly so called, right? Customary law, of course, customary law is not issued by sovereign. So for him, for Austin, this is not law properly so called, and this invalidates the entire common law idea that law is customary, in the sense that it has stayed so long, and that is why it has validity. But for him, customary law in and of itself is not law, because it is only law when the sovereign validates a custom. For example, Hindu Marriage Act. What does Hindu Marriage Act do in India? It takes a set of customs and gives them legal validity by the force of the parliament, right? So customary law can become law only when it is sanctioned by the sovereign, not without it. And lastly, he calls constitutional law not properly so called, right? Which is sort of an irony, because we think of constitutional law as law in its purest sense, right? So but Austin refers to them as not properly so called, because again, it is not issued by a sovereign. It is something that again limits the powers of the sovereign, which is again a critique of Austin. We'll come to that. And yeah, these are all what he calls law by analogy. And law by metaphors is something that we call law, but it is not actually law in any sense, because for example, laws of physics, they're laws by metaphor, in the sense that okay, there are laws, that everything just comes down. If I try to defy laws of gravity, and try to fly off a building, I will be punished by plummeting down and just poofing into pieces, right? So yeah, it's a law. And, I mean, like in law of gravity, you cannot be Superman, and if I try to defy it, I'm met with the punishment of nature. But it is a law by metaphor, but it is not in a sense law as we understand it to be. So it is a law by metaphor, and it's an improper usage of the word law, according to Austin. Now, the job of judges now remains, instead of grasping into some historical or time immemorial idea of customary law and to extract legal doctrines out of it, what the job of the judge is reduced to is analyzing the laws, best to best analyze the laws of the sovereign and to apply them, right? So what happens in that case is that the role of the judge is reduced to that of a craftsman who specializes in the act of interpreting the laws that are put forward by the sovereign, right? So that is the job of the judge according to Austin. And we talked about a scenario where, in HLA Heart, HLA Heart says that, what happens to you? I mean, what happens when a robber comes to you, points a gun at your head, and asks for your money? And how is that? How is a lone gunman's order different from that from a law? So Austin according to Austin, if you have to go by his ideas, firstly, the law or the order of the gunman needs to have some sort of generality. For example, it is a very specific command. I'm pointing this gun at you. You give me your money, right? For it to have a generality, robber has to say something like, every month, at every middle of the month, 15th of the month, you give 15% of your income to me as ransom, right? It has a sense of generalities, and there's a sense of regularity in that. Now it has become general, and what are the other ideas? It must be internally supreme, and it must be externally interdependent. Idea of sovereignty. I mean, there must be no external or internal uh, consideration acting upon the robber. I mean, because at the end of the day, robber is also subject to the laws of the state, right? For example, here our robber has to be the master of an autonomous zone, according to Austin, if the order of the gunman is supposed to be the law. And the orders must be addressed to a group rather than an individual. A group of individuals have to, submit their money to the robber every 15th of the month, 15% of their income. And the order must be of a standing nature. That is, that is, they must apply, not only to a single occasion but to general occasion. Of course, this idea that, uh, there is a generality in law. So the idea of generality contains it, and then the order must be, and there must be a general belief that the sanction enforcing orders are likely to be implemented to the extent of a disobedience. That that people are actually punished for disobeying the order, or for disobeying the orders of the gunman. So yeah, this is what it takes. What is the difference between the order of a lone gunman and that of that of a law, in the Austinian sense of the term? Now we'll come to the critique of Austin. Now, one of the most famous critiques that are ever offered in I think all of legal theory is the critique that Hart launches against Austin in chapter 3 and 4 of his book, The Concept of Law. He has basically three sets of critiques against Austin's ideas. Um so, firstly, the first critique that HLA Hart has against the idea, against Austin's idea of law, is that laws as we know them are not commands backed by threats of sanction. Now, why does he say that? That laws are not commands backed by threats of sanctions. He gives three reasons for that. Firstly, he talks about how nullity is not a sanction. Okay, so he talks about, okay, he says that, okay, there are some laws that resemble Austin's idea that laws are general commands backed by threats of sanction, and these are criminal laws, right? Criminal laws are like general commands that are backed by threats of sanction. But what about laws prescribing ways of valid contracts, wills, and marriages, right? For example, there is a law that every marriage that is to be that is to be conducted, it has to have two witnesses, or every will that is to be executed, it has to have two witnesses, right? What happens when this condition is not met, that two witnesses are not arranged for a will to be executed or marriage to be conducted? Is that the marriage or the will is declared to be null and void. But is nullity a sanction? Austin thinks that it is. I mean, in the sense that it is withholding of a sort of an award that the law bestows on you. But Hart says that that is not true, in the sense that it is a very reductive way to look at what you know I mean, what sanctions are. It's not a very reductive in the sense that it is a very broad idea that that nullities are also sanctions. This is not a view that Hart agrees with. uh, and he says that for example, where a measure fails to become law because a requisite majority is not meant to pass that, in for example in the parliament, then the law elapses, right? So what is happening here is not in a sense a sanction. I mean, if the parliament cannot meet the requisite number of majority for it to pass the law, then according to the rules it is not law. But it is not in a sense a sanction against the parliament, so to speak, right? So in a sense that this idea of this idea of nullity being a sanction is not digestible to Hart. Secondly, he talks about self-binding commands. For example, the range of applications of law, if we describe them to be orders backed by threat of sanctions, uh, then I mean that does not agree with the idea, because sometimes parliament is itself bound by some of the laws that you know that it passes, right? For example, it makes some amendments in the rules of procedures of Lok Sabha. What does it do? It makes rules that are binding on itself. So in what sense can you say that you can command oneself, right? I mean, you cannot command your own self, because that will be contrary to the idea of command, right? Command is something that is a signification of desire from a political superior to a political inferior. You cannot command yourself, because and it is because of that this is this is an idea that Hart is not able to basically come to terms with. But he tries to portray Austin's idea in the best light possible. So he talks about he says that a defender of Austin may say that the sovereign here is acting in two different capacities, right? That of a lawmaker and that in its private capacity. So they're playing, the sovereign is playing two rules, the one who's passing the law and one is obeying the law. But Hart says that it is not a very good description of what actually occurs, right? Because what the legislator does is exercise powers conferred by the rules within the ambit of which with the ambit what he's doing is exercising powers conferred by rules to them. And this is something that Hart will talk about in his theory of law as rules guide, as obligation constituting rules. We'll come to that when we discuss Hart's theory. And lastly, what the problem that Austin raises is the problem of customs. He asks, how do customs gain the force of law? They do not resemble commands backed by threat. And an Austinian would say that okay, customs acquire the force of law through the tacit order of the sovereign, that his judges to his judges, that the certain customs should be treated as law, right? So even if an act is not passed by the parliament, there's certain customs which that are recognized in legal system that are given the validity of law. So he so like Hart asks, how do they have the validity of law? An Austinian, he says, would say that they are laws by the tacit agreement of the sovereign, right? So in the sense that judges apply these customs, and the sovereign chooses not to interfere. So this non-interference in the sense becomes a tacit acceptance of the customs as law. So they still become something resembling a sovereign command, right? uh, so he gives the Hart gives the example of a sergeant who asks his subordinates to perform certain drills and punishes them upon failure. And then the general of the army comes to know of this. He chooses not to interfere, and this non-interference can be seen as a silent substitute for words to order that drill in the first place. So yeah, custom becomes a law by a deliberate datable act. But Hart does not agree. He says that the fault lies in the fact that in practice it is rarely ever possible to pin down, as to when a sovereign learns of a custom and then decides not to interfere then. For example, a legislation is passed by the parliament, right? And that does not mean that the legislation does not have legal effect till a court takes that legislation, applies that in a case, right? They have legal validity independent of their application by a court of law. So customs in that sense should also have a validity independent of their application, right? So I mean, if you look at it from that way, um if you look at it from that way, then customs, it is difficult to conceive of customs as a part of the sovereign enforced law. So I mean, these are the objections that Hart has to the idea of laws being general commands backed by threats. Another objection that he has is that the notion of habit of obedience is very deficient in that case. For to portray that law, Hart tells a story. So there is a land which has had monarchy for a long while, and there is the king called Rex, and the general populace abides by the rules of Rex, and are likely to do so. Now, what happens is that Rex dies and leaves Rex two in charge. Now, it is according to an Austinian, it is only after Rex two orders have been obeyed for a time can we say that people are in habit of obedience to him, and that is only when he can be an Austinian sovereign. So, according to this idea, during this intervening time, until which between which we are not sure whether Rex two's order will be habitually obeyed, uh, as per an Austinian, there could be no law, right? So what is happening is that there is a facade going on. There's no law that is going on that is passed by Rex two in the initial period of his accession, right? But yet in practice, we regard Rex Second's laws to be law from the very start, right? So it also fails it to take into account how Rex's orders are still being followed. Rex One's order is still being followed without Rex Two's tacit consent, right? So in a sense, there is a problem that Austinian theory faces. To explain continuity of legal norms. I mean, in a sense, sovereigns change all the time here and there, but the continuity of law is still maintained, right? Um, and basically, if a person is trying to defend Hart's theory, will say something like, "Oh, the people who are the actual sovereigns behind the sovereign at the scene in a democratic government, right?" So, I mean, to an extent, it is again, it brings us to the same problem, right? How are people the sovereign at the same time they are they are people who are following it? Then we have to again rely on that separation between citizens in their private capacity and citizens in their constitutive capacity, and it's a whole lot of mess. And another objection that Hart raises is that Austin's notion of limited, right? Um, Austin's theory requires sovereigns to have unlimited power to make laws, but that is not always true because most sovereigns, I mean, not the sovereign in, I mean, probably not the sovereign in United Kingdom, but most sovereigns are limited by written constitutions, right? So lawmaking bodies have a limited sovereignty in the sense, right? And what about also about lawmaking bodies that are limited by higher lawmaking bodies, for example, states and center. In United States, every state has the power to make laws, but at the same time, they also pay habitual obedience to the federal government, right? So, in the sense, do they not have like independent existence, apart from federal law? I mean, these are some sort of problems that Austin's theory necessarily comes in contact, comes in question with, and we'll see how Hart addresses them in his part of the theory. Um, Now let's focus on Kelsen, Hans Kelsen, another positivist theorist, and let's see about how he tries to rectify some of the concerns about Austin's theory and how he's different from Austin in the terms of his own project. So now, what Kelsen wanted to do was he called his theory of law the pure theory of law, right? So he says that what he wants to do is to extricate law from the metaphysical mist that has surrounded itself, that has surrounded it at all time. So what he wanted to do, in a sense, was to identify the essence of law and wants to rid of it of its extraneous elements, right? So what he's doing is, he's responding to a bunch of his contemporaries who are, who are philosophizing at the same time. Kelsen was writing in the early 20th century, before and during the First World War, and yeah, essentially almost separates Austin and Kelsen. So that is also something that is true, and there's already there's a lot of work that's been done by in jurisprudence at that time. So he's responding to theories of law which see only which see law only as a branch of sociology or a part of nations historical traditions. uh, the sociological school of jurisprudence, as it was called, was one of the principal founders of it was Roscoe Pound, also called Dean Pound affectionately, because he was the dean of the Harvard Law School somewhere around 1916 to 1920. I mean, I'm not exactly sure of the dates, but he was the dean of Harvard Law School at around that time, and he basically called positivist jurisprudence slot machine jurisprudence, right? Sense that what these people are doing, what Austin theory does, is that you put in sovereign made law at one point, at one end, and you get judge made application of it another. So it's a very mechanical process, according to Roscoe Pound, and he wanted to sort of ground law into sociological elements. That law is something that is supposed to solve problems of the society, and it cannot be separated from the sociological problems that society has. But Kelsen disagrees with that. He wants to situate law purely in the legal domain, and that is separate from all these extraneous conditions that might affect the law. And another school that was popular at that time was Savigny's historical school, which according to which law is something that organically develops out of the traditions and customs of a native place. And what the sovereign does, in a sense, is just recognizes that those laws that are organically emerging from society and applies them, right? So in a sense, you can see you can see in Savigny's idea some sense of that, again, the old common law idea of customary law sort of emerging. But Kelsen is trying to distinguish his theory from all these people. Says that no, when I'm talking about is a pure theory of law. I think it is a theory of law that is in itself, that's identity lies in a theory of law that is independent of any extraneous consideration. So he calls, I mean, his idea of law is that it is a set of directions to officials, right? That is the first element of Kelsen's theory of law, is that it is a sort of a direction to officials. Law tells officials how to act. So it is the nature of a set of deductive propositions. If so and so happens, then you should do so and so. For example, a law may say, if a person is prosecuted for an alleged crime, then try him. If he's found guilty, then sentence him. So what emerges then is a set of legal norms that are a chain of if then proposition, where everything can be deductively concluded from the previous proposition. For example, the Wills Act requires two persons to be witnesses in signing of a will. If a person doesn't comply with this requirement, you have to declare the will void. If the beneficiary still seizes property and their kins come to court, hold the beneficiary in contempt and send him to jail. So the last direction to the official in this chain of cause and effect relationships would be the last direction to the official would be to close the door and turn the key of the jail, right? That is where the process stops, right? So again, if law is a set of directions to the officials, um begs that if it is always that one proposition leads to another proposition, we can trace back the propositions as well, right? So what is at the top is the question that Kelsen is asking, right? So for example, what is the validity of an executive order? The executive order has validity because it comes from a statutory act. What is the validity of the statutory act? The fact that it is enacted by the authority of the parliament. Where does the authority of the parliament come from? It comes from the constitution. Where does the authority of constitution come from? We don't know, right? So what Kelsen says that if we keep going back, there will obviously come a time. There will obviously become a point from where we cannot go any more back, right? I mean, you can draw parallels to Aristotle's idea of infinite regress. That I mean, we can ask questions about what comes before that, and we must reach a first cause, so to speak, which cannot be knowable because I mean we cannot understand them through a series of cause effect, right? So for Kelsen, that point that the first proposition of law is is what he calls a grund norm, right? So a grund norm is a norm which jurisprudence cannot explain, but it can only accept, right? Uh, so in a sense, a grund norm is not, so the paradox that grund norm presents us like a constitution is law in its purest sense, in the sense that it is the most fundamental law and all laws are derived from it, but it is not law in the sense that it cannot be traced to any further legal authority that gives right. It is a political and sociological fact that jurisprudence must can only accept, it cannot question it, according to Austin. Because even if we try to reason back, in the context of Indian constitution, we can say, oh, it was enacted by the British. So what gave British the authority? Some rules of the kings, previous constitutions. There must come a point where we can just we have to stop, right? In India's case, we generally regard the grund norm to be the constitution itself, because I mean Article 395 of our constitution repeals the Indian Independence Act and the Government of India Act. So we cannot, in the sense, refer to a previous act because constitution in that sense has a independent existence, the Constitution of India at least. By virtue of its provisions, and you cannot point to anything else to show the validity of the constitution in that sense. So I mean, the idea of law that Kelsen gives us is a sort of a pyramid structure with the grund norm as at apex, and the grund norm is leading further laws, right? So for Kelsen, law is a process of development of legal norms through concretization, which goes from a specific, which goes from a general to specific norm, right? So for example, constitution contains very general norms about how country is to be governed and how rules can be made, what are the limitations that we can impose on rules, right? For example, fundamental rights, any rules cannot, no rule can contradict fundamental rights in that sense. So these are very general guidelines laid down, and then we have a bunch of acts that a bunch of laws that sort of emerge from that, and which sort of add specificity to the laws that are enabled by that are enshrined in the grund norm of the constitution. So this is it. And what is the test of efficacy that Kelsen holds, for his laws? He says that a legal system is functioning and the laws our laws are efficacious if there are twofold. It's a twofold test. First, he says, is whether to see whether the rules can be deduced from legal norms and are obeyed. Yeah, that is the first rule. And the second rule is, if they're not obeyed, whether the primary norms that direct officials to take specified action is complied with, right? So what is happening here is that firstly you see whether the rules are being obeyed. If they're not being obeyed, are the officials doing things which are supposed to which they're supposed to do according to the legal norms. So yeah, I'm sorry. Yeah. So yeah, when we are talking about so yeah, these are the basic. This is basically Kelsen's theory of law. Now we'll come to critique of Kelsen's theory. So HLA Hart recognizes that the idea that laws are essentially what they are is like directions to officials, is a formidable theory, and it is a very interesting theory. But Hart thinks that it does not accurately represent reality. Why does he think so? Because he thinks that the primary function of law as a method of social control, is not actually its private litigation or prosecution processes that we see in that officials take out, but it is a vital, but it is an ancillary provision that happens in case of failure of the system, right? What rules, what law is primarily supposed to do is to guide human conduct, right? And which is something that Kelsen just does not talk about, is silent about, right, in a sense. So which is very curious that Hart finds about theory that is propounded by Kelsen. So yeah, we've talked about Austin and Kelsen so far, and before we go into Hart, we'll take a short break. If anyone has any questions or comments or any observations, I mean, please go ahead. Another thing I talked about today, I will talk about legal positivism, legal, uh, and neo-naturalism, as in like the modern theories of natural law, and also legal interpretivism, and in addition to that, critical and postmodern approaches. And because of I mean, the time was not, we did not have a lot of time. I thought that it would be a bit. I mean, I would not be able to do justice to critical and postmodern approaches, because they would take time and explanation and background. So I thought that instead of doing that, what I'll do is that I'll complete these main approaches towards law, and then I'll share a short reading on these approaches, which will, I mean, explain these approaches far better than I can in the short amount of time. I hope that's fine, Asad.
Yep, absolutely.
Yeah. Okay. 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 Thank you. We'll only talk about legal positivism, neo-naturalism, and legal interpretism, and after that, I'll share the reading on critical and postmodern approaches. Um, Okay, so now let's talk about HLA Hart. HLA Hart is, at least in the positivist tradition, he's considered to be one of the greatest legal philosophers of 20th century, and because the kind of theory that he gave of law is, it's very comprehensive. It's a bit complex rather than a reductive understanding that Austin's theory might give, and it is also, it has opened like numerous talking points and points of debate within the legal cultures, both in the traditional cultures and the critical cultures. So it is very important in that sense. So what HLA Hart basically says, I mean, his theory is that law is a system of rules that constitute obligations. But that is like, his theory is not like Austin, which can be contained in one sentence. So we'll have to understand what exactly he means by rules that constitute obligation. So Hart says that there are two types of two sorts of things that influence human behavior: social rules and social habits. Now, social habits are, for example, you might have a habit of going to cinema every Friday, but that's not a rule, right? That is just a habit that you have. It is different from a social rule in the sense that, for example, you have to take your hat off when you enter a church. It is an example that Hart gives. This is an example of a social rule, because if a person fails to perform latter, they will be criticized, and their criticism will be deemed warranted even by the person who's being criticized, themselves, right? So I mean, you will not be criticized if you fail to go to cinema on Friday. So it's a social fact, and the latter is a social habit. And what is the differentiating factor between social facts and social habit? Hart says that while social habits only have an external aspect to them, social rules have both an external and an internal aspect to them. Now, what does that mean? Uh, so the internal and external aspects of the rules, Hart talks about it. It's a very important point of his theory. An external aspect of a rule he defines as, the fact that the rule is something that a social rule is something, is kind of a fact that is observable by anyone looking at a group from outside, whereas the internal aspect is the awareness of and support for a social good. I'll give an example. For example, wherever whenever a vehicle passes a traffic signal, it is a rule that if the signal is red, then the vehicle must stop. Like, it is a social rule. Now, it has an external aspect to it, in the sense that if someone is observing it from the outside, they will observe it that, a number of times, that whenever a vehicle comes in front of a red light, it stops, right? And they can almost treat it as a sign that if the right light is red, you can almost treat it as a sign of the fact that the car will stop, right? But just this fact does not make it any different from a social habit, right? For example, if a person is observing the relationship between a red light and a vehicle stopping, and Friday and me going to cinema, they'll not observe any difference. It's just that, when a certain conditions happen, behavior is observed. what differentiates these social habits and social rules is the fact that there is an internal aspect to there's an internal aspect to these social rules, in the sense that whenever we as people who are driving vehicles, we see a red light, we feel morally compelled, we are aware of the fact that we have to stop, and we support the social rule that we have to stop. This is the internal aspect of the rule, which is missing in case of a social habit, right? We do not feel the internal need to follow the rule that every time we a Friday comes, I have to go to cinema. It's my discretion, I can skip also, right? But I do not, it's because just I choose to, not because of some social pressure and not because of the existence of a social rule. So this is basically a difference that Hart rules out between social rules and social habits. Now, um, what are the types of social rules that Hart talks about? So we have differentiated social habits from social rules. What are the types of social rules? He talks about two types of social rules: rules which are no more than social conventions, and secondly, rules which constitute obligations. Right. So let's talk about the first one: rules which are no more than social convention. For example, taking your hat off in the church, right? Rules of speech or etiquette, right? A group strives to see that these rules are observed, and criticizes those members of the community who do not observe these rules. But they do not constitute obligations, in the sense that there is no insistent demand that members of the group conform, and there's no great pressure on them to that is brought to bear on those who break the rule, or or even threaten to do so, right? So the rules that constitute obligation, there is an insistent demand from the group that that people should conform to it, and if you break the rules, you will be met by you know you'll be met by consequences, serious consequences. uh, so now, we have talked about two rules that are merely social conventions and rules that constitute obligation. Now, the rules that constitute obligation are also of two types. Hart says they are rules which form a part of the moral code of the society concerned, and secondly, rules which take form of law. Rules which form the part of a moral code of a society concerned is, in a way, it can be wholly customary in origin. There's no central body that is punishing for the breach of these rules, but if but there is a very strong pressure to conform to these rules, and there's a hostile reaction that the rule breaker receives in case the rule is broken, right? The pressure for conformity comes from the words of disapproval or appeals to individuals' respect for the rule broken, and the pressure that may be relied upon for the conformity of those rules is feeling of shame, remorse, or guilt in the offender, right? To the point that that there is no, I mean, you feel that you have this obligation to obey them. You cannot not obey them, right? But they're still different from rules which take form of law, right? A rule comes into the category of law when there is a threat of physical sanction against the person who breaks these rules, is what Hart says. It does not matter if the sanction is applied not by officials but by community at large. It does not matter. This Hart says. So in a sense, primitive law can also be law. So these are the forms of rules that take the form of law, according to Hart. Further, he talks about the law constituting rules. He talks about two kinds of them. One is the primary or duty imposing rule, or secondary rules, or the secondary rules, which are rules about rules in a sense, right? So primary rules are duty imposing rules. They tell people what to do or what not to do, or what is to be done. That is what primary rules do. And secondary rules are rules about rules, and what does that mean? They're rules about how these rules are supposed to be formed, how they're supposed to be recognized, how they're supposed to be enforced, how they're supposed to be modified, how they're supposed to be extinguished, right? So there are rules about the application and amendment of these primary rules. uh, Hart asks the question: can a society exist without secondary rules? He says that it can, but it can only happen in small communities, primitive communities, and primitive in double quotes. And that is the word that Hart uses, which are problematized by many critical theorists. And what is even primitive? Because Hart did not go and observe any so-called primitive communities to say how He's just I'm just thinking, oh, from his armchair about how primitive communities function. But yes, he says that these primitive communities, which are small, which are knitted by kinship and common values, in these we do not necessarily need to have a set of secondary rules, and only primary rules enough. But there are many problems that may emerge if we try to operate in secondary without secondary rules in large societies. You do not know when to recognize the rule. If there's a conflict between two rules, how do you solve them? How do you enforce these rules? These are some of the problems that emerge. So in larger societies, according to Hart, secondary rules are important. He secondary and Hart talks about four types of rules, secondary rules that constitute a legal system. They are rules of recognition, rules of change, rules of adjudication, and sanction imposing rules. Right. Um, and rules of change are, of course, how rules are to be amended, added, removed. Rules of education about how these rules are to be implemented. Sanction imposing rules are, for example, rules that say, for example, that a person should be punished in case that in case punished for 7 years if that person steals, right? So primary rule will be you should not steal. Sanction imposing rule will be that you will be punished with 7 years if you steal. But among these, the most important for Hart is the rule of recognition. As per Hart, wherever there is a rule of recognition, people have a way of finding out what primary rule is. Right. So something akin to a rule of recognition may be, for example, whenever, whatever the Queen in the Parliament enacts as a law, it can be considered to be rule of recognition. But Hart would say that it is reductive because it ignores a whole host of other factors that go into forming things like customary law or judicial doctrines, right? So so rule of recognition cannot be understood in this very reductive sense that whatever Parliament enacts is the law, whatever XYZ, whatever the sovereign says is the law, right? It is so for Hart, rule of recognition is not something that can be simply stated, but it is actually a more complex set of attitudes held by legal officials, right? That is judges, legislators, about what constitutes law, right? And a very important thing that he talks about legal officials. So it is not the people who are participating in the rule of recognition, but rather it is the officials who are participating in the rule of recognition. Officials are coming to consensus about how we recognize some things as law and how we don't recognize this law. So whatever the dominant notion about legal validity is among the legal officials, that constitutes the rule of recognition. So yeah, this is basically Austin's theory of uh, of law. Another important thing before we go to our next school, neo-naturalism and legal interpretism, is what is the connection, what is the relationship between law and morality for positivists like Hart, right? Because in a sense, like of course, you cannot say that morality, law and morality are completely independent, because even Austin recognized that there is a science of legislation which sort of dictates how laws are to be made. So what and which are, of course, to be morally determined, right, by whatever ethical theory you're going by. So what is the relationship between law and morality for Hart? So there are two types of positivism: inclusive legal positivism and exclusive legal positivism, that emerge sort of out of Hart's out of Dawkins' criticism of positive law. We'll talk about Dawkins' criticism later. But the general idea is that inclusive legal positivists um, believe that while positivism says that law is not to be identified with morality, it does not place a restriction upon laws to not draw from moral principles, right? Laws can draw from moral principles, but at the same time, it is not necessary, because that is not a condition of validity for them, right? But exclusive legal positivists, they believe that law must be separated from morality, because the basic thing which exclusive legal positivists like Scott Shapiro say is that that if you take inclusive legal positivist point of view, that law, that law can actively draw from morality, what you're trying to do is you're trying to defeat the very purpose why positivism was there in the first place, right? So what so for exclusive legal positivists, what basically happens, what the relationship between law and, I mean, the purpose of law is to strictly separate law from morality, because if you have to reach for morality every time, what is the purpose of positivism? What is the purpose of laying down these concrete legal rules which are not dependent on ambiguous things like morality, right? So, for an exclusive legal positivist, they go by Hart's idea of the open texture of law. So Hart talks about how laws have an open texture because rules are necessarily finite, right? There's a point at which rules will obviously run out, and there are difficult cases where where a positivist says that, okay, we do not have any existing legal rules for this. What do we do? Then they then they draw these rules from external considerations like. External considerations like morality or policy principles, and then when they're recognized, then they become part of the rules within the legal system, and then they are to be applied uniformly. So this is how basically the positivist, at least in modern positivists, think about the connection between law and morality. So yeah, this is the end of Hart's theory of law. Now we'll move on to. We'll just ask if there are any questions, any observations, suggestions before we move on to neo-naturalism.
I think we're all good.
Okay. In that case, I'll move on to neo-naturalism. I'll be talking about two main theorists, John Finnis and Lon Fuller, which are like two of the most prominent neo-naturalist theorists, and they present very different views of what natural law is supposed to be. First, we'll talk about John Finnis. John Finnis takes himself to be developing on the views of Aquinas and Blackstone, in the sense that their ideas of natural law. He takes himself to be a successor of these, right? But as we said that he does not engage in a theological exercise to determine what principles of law should be. They're derived from very secular ideas and in a sense very non-theological ideas, according to Finnis. So according to Finnis, the classical naturalists were not concerned with the criteria of legal validity, but rather with the moral force of law, right? So what he quotes is that the natural law explain the obligatory force of positive law, even when those laws cannot be deduced from that principle. So in a sense, what Finnis is trying to do is that although classically positivism has been put at odds with naturalism, he does not think so, because he thinks that what they are talking about is criteria for legal validity, but what we are talking about is not criteria for legal validity, but rather something that gives that determines whether that law is a just law or an unjust law, or what is the moral force of that law. Because Finnis thinks that the essential function of law is to justify state coercion, right? So if the function of the law is to justify state coercion, under what condition is the state coercion justified, right? Because you cannot say that just because it has been a law has been concluded by a set of factors that meet the criteria for legal validity, you can say that, oh, the state can exercise coercion in that case, right? So I mean, state coercion should be, because in state coercion is a political act, so state coercion must be politically and morally justified, right? That is what Finnis says. So what he concludes is that an unjust law can be legally valid, but it cannot provide an adequate justification for the use of state's coercive power, and hence they're not obligatory in the fullest sense, right? So unjust law may be legally binding, but it is not fully law in the sense that what law is supposed to be, right? So like classical naturalists, Finnish naturalism is both an ethical theory and a theory of law. It distinguishes a number of equally valuable basic goods, that is, and he lists them, right? What he thinks are basic valuable goods, which he thinks should be pursued for their own sake and not to bring about something else, to basically assist in bringing about something else. These basic equally valuable groups he state as: firstly, life; secondly health, thirdly knowledge, fourthly play, fifthly friendship, sixthly religion, and seventhly aesthetic experience. Now religion he does not says in the sense that a god sort of religion, but the belief that there is a higher order to things than that each individual person, that is what he calls religion. So these are the 1, 2, 3, 4, 5, 6, 7, yeah, seven principles, I think. Yeah, the seven principles that he talks about, that he says that are equally valuable basic goods which should be pursued for its own sake. And one of the criticism is that these are oddly specific, and why should these be considered the basic goods and not something else? I mean, Finnis does not talk about it. Margaret Davies is like very acerbic in her criticism of she's a critical legal theorist, and she's very acerbic in her criticism of Finnis, in the sense that it sort of gives this for idea of human nature, which is sort of universal in its nature. And what this leads to is obviously imposition of one set of ideas about human nature, that is the Western idea of human nature, onto every, and considering that to be a universal application, right? So that is one criticism of Finnis' idea of equally valuable basic goods. But okay, like, coming back to Finnis' theory. So, according to Finnis, each of these things, given the human nature, are valuable in their own right, and not merely for the sake of some other good that they can bring about. And the role of law is to facilitate the common good by providing authoritative rules that solve coordination problems that arise in connection with the common pursuit of these basic goods. Now that's a long sentence. Now let's break it down. But it's trying to say that these goods are like basic in the sense that they are good in their own right, and what the law should do is that he says that they often come in conflict with each other, right? I mean, aesthetic experience may come in view of knowledge, and play may come in view of friendship, health may come in the way of religion, whatever. So what the role of law is to mediate between these goods, so that in the common pursuit of these goods, they do not come into conflict with each other, is what Finnis tries to say. So this is Finnis' theory of naturalism. It's also called substantive naturalism. It is contrasted to Lon L. Fuller's procedural naturalism, right? So let's come to Lon Fuller. Fuller rejects Finnis' idea that there is a necessary substantive moral contains in the content of law. So what Fuller is trying to say is that it's not true that the content of law is sort of naturally determined, in that sense that there is some specific objective criteria out in the air somewhere, which from where you necessarily need to derive your idea of law from, right? That is what Finnis is trying to say, and Lon Fuller rejects that, because content of law is like very subjective in the sense that it is different in societies. So what he's trying to, on the other hand, what Fuller is trying to say is that uh, it's an idea of a procedural naturalism. What does that mean? That there are some things that are natural about the way that laws are passed and the laws are laws are enforced, rather than something natural about the content of them, right? So for Fuller, human activity is necessarily a goal oriented and purposive endeavor, right? In a sense, so humans always engage in activities to achieve certain ends, is what Fuller says, and you can already see the influence of Aristotle on Fuller, right? The teleology of mind. There is that the purpose of law is always oriented towards, purpose of all human activity is to oriented towards some ends, and Fuller says that the end that the law seeks to achieve is also very purposive and end oriented in that sense. So the purpose of law, according to Fuller, is, and I quote, achieve social order through subjecting people's conduct to guidance of general rules by which they may orient their behavior. This is a quote from Fuller's Internal Morality of Law, where he propounds his theory. So what he's trying to say that that law is basically a guide to human conduct that is addressed to rational people to moderate their behavior, right? and and he says that something cannot be law if it does not meets these considerations, right? So if something cannot guide human conduct, it cannot be law, right? So Fuller talks about a set of necessary conditions for the validity of law, right? So the first criteria, and there are these are set of eight criteria that he talks about, eight criteria for the validity of law. For the for a law to be law in that sense. The first criteria is that rules must be expressed in general terms, right? They should not same idea as Austin, that law should be expressed in general terms. I talked about in the Fuller's idea of managerial command. So a manager can on his whim just decide to give different commands to different people and at whimsically change whatever commands that they may see fit on grounds of expediency, on the grounds of achieving some end. But law is not that, because if the laws are not are very specific, they cannot guide general human conduct in that sense, right? So laws, the first rule is that laws must be expressed in general terms. Secondly, laws must be publicly promulgated. Now what does that mean? By saying that law must be publicly promulgated, it says that laws cannot be secret laws, right? I think we talked about this yesterday. Why Fuller talks about laws. I talked about it in like very short, but I'd like to expand on it. What he basically tries to mean is that there cannot be secret laws as they were in Nazi Germany, right? They what Nazi Germany did, that they enacted a bunch of laws, did not tell anyone that these are the laws that we've enacted, and just used to randomly arrest people if they were satisfied, if the officials were satisfied that the law has been broken, right? So what it is effectively doing is that laws are not being publicly promulgated. I mean, if the laws are not publicly promulgated, are they even law? I mean, they cannot guide human conduct if they're not publicly promulgated, right? So yeah, this is the second principle. The third principle is that rules must be prospective in effect. They cannot be retrospective. You cannot guide someone's past human activity, right? So in a sense, Fuller's idea would be inconsistent with the idea of common law, right? I mean, common law is like you decide law when it comes, as and when the cases come. He does not agree with that, right? He's saying that the laws must be laws must always have prospective effect and not retrospective effect. And fourth principle is that the rule must be expressed in understandable terms, right? Because if the laws are not understandable, if the laws are very complex, if the laws are not very clear, they're not good laws because they cannot guide human conduct, right? So human conflict, and that is like a criticism that we can make towards judges who write long and just sufferable judgments that are pain, even for law students to understand, let alone like common people, right? So laws must be clearly understandable, otherwise they will not be able to guide human conduct. And fifth rule is the rule that that the fact that rules must be consistent with one another, right? So for example, if there are conflicting views, then they cannot guide human conduct, right? If one rule tells you to do X thing, one rule tells you to not to do X thing, then they cannot intelligibly guide human conduct. So for 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 rules to be laws, they should not be in conflict with each other. uh, Sixthly, the rules must not require conduct beyond the powers of affected parties. um, for example, the idea of the privity of contract, right? What is the idea of privity of contract? That that it is the only the contracting parties on which the contract can confer rights and obligations onto. They cannot, a contract between two people cannot confer rights and obligations onto a third party, because that will be just that will be against the, I mean, how can private contract between two people regulate the behavior of a third person, right? So that is something repugnant to the idea that law is supposed to guide conduct. So yeah, so the rule must not conduct beyond the powers of the affected parties. That is one rule. And the seventh rule is that the rules must seventh principle is that the rules must not be changed so frequently that the subject cannot rely on them. If every now and then in parliament every month is enacted new and different laws, what is happening is that there's no clarity about what are the rules that exist, right? If there's no clarity about rules, then how can it intelligibly guide conduct, right? So it is so changing rules very frequently is detrimental to the idea of law as it's supposed to guide human conduct. And lastly, the rules must be administered in a manner consistent with their wording. Very important, because if law says one thing and its application, the judges draw an interpretation that doesn't stays so away from its letter of the law that that people cannot just make out what the law is just by referring to it. What is the point of having laws that are supposed to guide them? Because if you cannot infer what the laws are by reading the laws, then what is the point? How are they supposed to guide human conduct? So these are Lon Fuller's principles, which are the ones that he lays down before to basically say that. Yeah, so I'm sorry, yeah, I zoned out. So yeah, so basically these are the rules that he talks about, that if law is supposed to be law in its full sense, it must it must comply with these rules. Otherwise, there's no, the purpose of law itself will be it will go away. So there's no point. This is what Fuller is saying. So yeah, let's take a break before we go to the final leg of our of our lectures. That is legal interpretism, or Dworkin's theory of law. Any questions? Any suggestions? Comments? Anything before we move on? Okay, if there are none, I would move on to legal interpretivism, which is Dawkins' idea of law. So, the most important idea of Dworkin is that Dworkin rejects the idea that Dworkin rejects the idea that laws are basically social facts. So yeah, that's a hit against positivists, right? Positivists say that laws always arise from social facts, some certain social facts that give rise to law. But this is a thesis that Dworkin rejects, and he's hitting at heart, uh, you know, when he says that. And he gives the example of a case that was decided by U.S. Supreme Court. It's called Riggs versus Palmer. So what happened in Riggs versus Palmer was, there was this guy, he was he was the beneficiary of a will, which was supposed to be his grandfather's, if I'm not, some relative, right? So now he was a very bad grandson, right? In the sense that he's very bad relative. He does not take care of whoever this person who made him the beneficiary of the will is, right? So now this person, the beneficiary, gets to know that his relative, that is going to sort of take him out of the will. So, and knowing that, what he does is that before his grandfather or his relative can take him out of the will, he goes and murders him, right, before he can take his name out of the will. Now whatever happens, he's prosecuted, he's punished, and after serving his sentence, he comes back and says that, okay, but the will was unchanged, and I am the beneficiary of this will, give me my money. Right? And yeah, of course, it caused a lot of legal commotion. The case went to the U.S. Supreme Court. And what the basic one, they were like they were I think there was split in the Supreme Court. Like, one of the judges said that, oh, our the law as it stands is that there's nothing that prevents him from gaining the benefit of that will, right? But the majority opinion said that no, you can they applied this principle that a man should not benefit, this principle, common law principle, that a man should not benefit from his own wrongdoings, is what it is, the principle that they applied. And they said that since what this person, the beneficiary, is trying to do, is trying to take benefit of an action, of a wrong action that he himself did. In this case, he cannot draw benefit of them, and that is why he was rejected the benefit of the will. So yeah, what essentially was done by the Supreme Court is that they did not let a person take benefit of the fact that he murdered someone, right? And this was not there in the positive law, right? There was no written law asking for this. What court actually did is just apply a principle of law, according to Dworkin. Now, I mean, if a positivist is reading this case, what a positivist like Hart would say is that in the court, what Riggs did was, Riggs versus Palmer, what they did was reach an extra legal consideration, right, to decide on what law is. But the question then arises that why was there a need to reach for an extra legal standard for subverting the rule when the rule already existed, right? The entire idea is that, I mean, as long as there is rule, you apply the rule. If the rule runs out, you apply morality, right? I mean, principles of morality or whatever. But the rule here existed. So Dworkin is not satisfied with the idea that, that laws are just rules that arise from social facts or whatever. Um, what Dworkin tries to say that law is both a set of formal rules, but also, a set of less formal principles, right? So yeah, so in some cases are very clear and decided. In that case, we do not need to reach out to this principle, but some cases are very hard cases, right? What these hard cases are is that where there is an apprehension that application of rules as they exist would lead to some sort of manifest injustice. In this case, what Dworkinian would do is to rely on these principles. Now, how are these principles derived? These principles are derived from something that Dawkins calls the aesthetic hypothesis. So what he says that the duty of a judge to interpret the duty of the judge is to interpret the history of law in its best light, right? This means to render a meaning of law that is properly integrated with with what has been going on before, and and something that is in consonance with the general values of the community, right? So this idea is something that Dworkins calls law as integrity. This idea of legal interpretation and decision making is what he calls law as integrity. Now, this is supposed to be read with and is supposed to be coterminous to John Rawls's idea of justice as fairness. So what Dworkin is basically saying: if justice is fairness, then law is integrity. If justice is supposed to represent fairness, law is supposed to represent integrity. To explain this idea of integrity, Dworkin gives the example of, the analogy of between law and a chain of novels written by several authors. What each of them is doing. One author wrote like one chapter, and another author, trying to make it look like a coherent book, is writing the next chapters in a manner that is in consonance with the previous chapter, and like there's a idea of the continuity that is being maintained through this. There's a narrative that is emerging, right? So each author is doing is try to write the story forward, keeping in mind what has already happened, and portraying whatever has already happened in its best light, right? That is what a judge is supposed to do. And Dworkin gives this idea of an ideal judge, Hercules, he calls him, that can review basically all the existing material in the entire jurisprudence, in the entire history of law on the current point, and then arrive at principles that that are best, that show the legal practice in the best light, right? So this is an ideal, of course. No mortal judge can just refer to all the existing material that possibly exist on the history at the current point and reach legal norms. But what he's trying to say is that all the judges should approximate this ideal of Hercules, right? And Dworkin, to explain how this process works, he gives the example of a game of chess. He gives an example of a game of chess that was played between Russian players and American player Fischer. And during that game, Tal was continually smiling at Fischer, and that was causing him annoyance and putting him off the game. Now, the rules of the game, the rules of permissible behavior with relation to the game did not say anything about smiling, right? So, if this case is referred to a referee, a positivist would say, okay, since there is no rule, what you can do is that you can, referee can use his discretion, and whatever he says will become, will become the rule carrying forward, right? So, referee can, in this case, can use his discretion, is what Hart is saying. But Dworkin says that this is not a good understanding of what what a judge or a referee is supposed to do. Dawkins says that a correct decision already exists, right? What the advice that what the advice that Dworkin would give to the referee is that you can know whether Fisher had the right to be smiled or not by observing the history, the nature, and the objects and the objects and the existing rule of chess. Right? What is the history of chess? The nature of chess, objects of playing chess, and the existing rules, existing body of rules of chess. Right? So. So he might come to a conclusion that the referee might come to a conclusion that, oh, since the chess is a game of intellectual skill, and requires concentration, the behavior of the opposite party can break a player's concentration, and it hinders the true test of the competing skills of a player, right? So in this sense, what basically is happening is that the intellectual skill of a person is not being tested fully, which is the object of the chess, right? So, from these factors and or possibly a set of other factors, the referee may conclude that there's a right inherent within the nature of chess. It is inherent within the nature of chess a principle that the player had a right not to be distracted by the deliberate conduct of another player. Right. Similarly, and just as an analogy, he says that as compared to football, a referee may analyze a similar situation that where a goalkeeper was being smiled at by an advancing player, and then they just conclude the opposite, because the nature of the chess and the object of chess, nature of football and the object of football does not require, it's a game of physical strength. It's not a game of intellectual skills that that require very hard concentration. So in that sense, the goalkeeper does not have the right to be smiled at by an advancing player. So yeah, so this is how, according to Dworkin, you engage in legal reasoning. You look at legal practice that has happened in the in the past, and the same way that a referee needs to look at the chessness of the chess to determine what the rules of chess may be. A lawyer, a judge or what is basically what is about that principle that gives it meaning, and which is historically given it meaning, that gives rise to of a rule of law at a current at any point. So yeah, in a sense, it is sort of theory given by Dworkin is like a intellectual successor to the classical theory of common law, in the sense that it is always historically derived, looking at how things have been done in the past and coming into, but at the same time it is a very modified and modern view of what lawyers of what judges are supposed to do with the ideas of precedent and etc etc. So yeah, this was Dawkins' theory of law. With this, we come to the end of our lecture series on philosophy of law. As promised, I will share additional readings on critical and postmodern approaches. But yeah, for now, this is all. Thank you very much. Thank you, Asad, for inviting me. It was a pleasure, and during the research for these lectures, I also learned a lot. So yeah, thank you for inviting me, and thank you for
I
doing
can imagine just the expanse of these lectures has been just remarkable. Thank you so much, Abhinit.
it. Thank you very much, Asad. You're very kind.
All right. So see you the next time. Take
Okay,
care.
okay, okay.
Okay.
I close the
Bye.
recording.
Yeah.
Thank you, Asad. Thank you, Avneet.